Welcome back to Legal Alternative Podcast with Sam and Nils. Nils, how are you?
I'm good. I'm good. You, Sam?
Very good, thank you. Nils, what we got coming up today?
So hopefully quite an interesting update on the ICO.
Yeah.
I'm conscious data updates that I often give are not interesting, but this one genuinely is quite a bit of potential upheaval that could follow with an ICO update. Then we're going to have a little discussion about what we're doing out of the office, and then a really interesting question on the Equality Act.
Yeah, so it is you first. What's in the inbox, Nils?
Yeah. So first ever ICO prosecution, let's call it.
Yeah.
It's a fine for a processor of data rather than a controller of data. And I appreciate they have technical meanings. But all the regulatory action, as I understand it, the ICO has taken for has been in relation to the controllers data. I suppose it's quite apt, really, because there has been quite a bit in the news recently about cybercrime. So if I remember rightly, Marks and Spencer's, I wasn't involved because I don't shop at Marks and Spencer's, unfortunately. Although I do like the food. They had big problems with a cyber attack. In relation to what I'd like to talk about today, I won't name the company who has been involved in this, but it's a company who they have cybersecurity products, and that's in relation to, I'm just going to read directly from the ICO quote, electronic patient records, clinical patient management, clinical disclosure, clinical decision support, patient care planning, workforce management. And it doesn't take a genius to work out which organizations would use that particular type of software, which we all pay into. So what actually happened was a hacker gained access to certain aspects of this company's system, and ransomware was used in the attack. And again, just reading directly from the judgment of the ICO, the hacker actually got into the personal data of close to 79,500 individuals. And the data was being held by 16 UK-based controllers of the data. So the company that was prosecuted by the ICO wasn't the company rather that actually controlled the data. It was a processor. The data included names, contact details, employment-related information, health-related information, and other sensitive information, national insurance numbers, racial and ethnic origin, and nationality. 41,000 individuals had their special category data hacked into. What the ICO found in their judgment was that the measures fell short of fundamental cybersecurity principles, with deficiencies found in respect of vulnerability, scanning, patch management, multi-factor authentication. And it was that particular last point that the ICO deemed to be critical. And as a result, this organization was fined and prosecuted. The ICO calculated the standard maximum penalty of £8.7 million, as this was higher than 2% of the group's worldwide annual turnover. So a big fine. Critical for two reasons. One, first ever processor of data that's been fined. So really big change in the ICO's regulatory viewpoint. Loss of a lot of personal data there shows that the ICO, when that personal data has been lost in that way, is always going to be at least interested, if not going to go the whole hog in terms of prosecuting and finding a organization. In terms of lessons to be learned, I think there's a number that come out of this. Vulnerability scanning, when you look at the judgment, that was found to be lacking. Timely remedial action. Once this has been found out, it's important that something's done about it, in the same way that when we did the health and safety trial, a big part that came out of that for anyone who was there is what have you done afterwards? Keeping IT systems up to date, and perhaps most importantly, when you read the judgment, is just how important that two-step login process is, the multi-factor authentication. So a really big decision. And it's important that processors of data keep up to date with their systems as much as the controller of the data, because the ICO has shown its teeth here, and I think this is a really important case.
I think so. And I suppose what the surprising things is here is, I suppose, why it's rare is the size of that processor. It's surprising, and I'm not suggesting that kind of hacking is easy, but they are that vulnerable at that size of that organization. This is something that the amount of data they are processing. You would think their systems would have to be so robust, and it is slightly surprising that it has been that vulnerable. But as you say, that two-step authentication, it's difficult, but massive fine.
Yeah, and there's a lot of solicitors would be one. We have controls and processors of data. Healthcare organisations another. I could go on and on, just because you think you processing data as opposed to controlling it, the same duties broadly are going to apply, and that's a really important decision.
Absolutely. So as you say, I think a lot of people, data protection, they go, "Oh no, not again." We appreciate that it can be dry, but it's that critical to go along with cybercrime. It's fundamental to every organisation. So it may seem dull and tedious, but it's one of the most critical things to any organisation. Right?
It is, and I think there's a view out there that this stopped in 2018. I won't name it, but I met a managing partner of another firm about 12 in 2019, and he said to me, "Is that not all finished now?" It's not. It's not. Absolutely, these duties are only going to get more burdensome. It's really important stuff as well, as it should be, to protect people's data.
I agree. In terms of out the office, I'm going to, again, a bit of a you podcast this week. We've talked about my running exploits in the past, but your Leeds 10K-ing this weekend.
I am. Got a jam pack Sunday. I've actually trained for this one as well. So I'm hoping to run sort of mid-50s really in terms of time. So we'll see how I get on. But I did the Wakefield 10K about 2 months ago, and my foot hasn't been right since. So we'll see how I get on with that. And it's a jam-packed Sunday really, because I'm then going to watch the Bradford Bulls play.
Wow.
So looking forward to watching one of our sporting clients play.
Yeah, it's not a bad one as a Leeds 10K. You've got that little hill at the end, which is a bit deceptive up past Little London, and you get that little hill. But as long as you're there all right at 9K, you'll breeze it, I'm sure. So no, fantastic one. I've done it lots. I'm away this weekend, so I can't join you unfortunately. But no, you'll smash it.
Thank you. And a really good question that's coming this week. We always get good questions.
We do.
I think this is a really good one. And is the menopause a protected characteristic of the vehicle?
Yeah, really good question. And something, again, we often talk about misreporting and, the kind of menopause. I've done lots of talks on menopause, and as an organisation, we've gone in and trained people, and I'll mention prevention and later. But the strict answer is yes, it is protected under the Equality Act, but it isn't a protected characteristic of its own right. So when we talk about the 9 protected characteristics, you'll see when you look at that menopause isn't one of them. It's died down a bit. There was a lot of debate in Parliament maybe 3-4 years ago that it should be. There has been some case law since then, which is maybe why that has lost some steam, but still there is lots of arguments that say it should be of its own. The reason why we still have protection under the Equality Act is there's been a number of cases on it now. The leading one, Rooney Leicester City Council, which was 2 years ago, I think, held that, and again, I'll be very careful with my language, that menopause symptoms are capable of being protected under disability. So we're talking about disability being the protected characteristic, and that menopause symptoms can. And so we need to be careful with language, because menopause itself isn't a protected characteristic, and menopause symptoms aren't always protected or defined as a disability. So they are capable. So what we look at then it's back to the Equality Act, and in terms of definitions under disability discrimination. So we're looking at these symptoms, so the menopause symptoms, having a substantial and long-term adverse impact on a woman's ability to perform daily tasks. So that's the key. It is substantial and long-term.
Yeah.
So the case of Rooney Leicester's City Council, and I say a few others, have been able to demonstrate symptoms such as brain fog, severe fatigue, have themselves being classified as substantial and having that long-term impact. So that again in turn has then been classified as a disability under the Equality Act. That's only half the story. We then obviously, in terms of disability discrimination, we need to look at then is there being kind of direct discrimination or arising from a disability, or in most cases, and Rooney Leicester City Council being one of them, is they're often reasonable adjustments cases.
Yeah.
So it's failure to carry out those reasonable adjustments when someone has a disability, in this case, the menopause symptoms being that disability. So absolutely something that clients and listeners should be aware of. We always advocate now, you should be having a menopause policy. You should be, obviously, anytime you're made aware of that, starting point, consider, well, do these symptoms potentially amount to a disability? Are there any adjustments that we can make? Again, look at those key words, long-term and substantial.
Yeah.
But bearing on the side of caution, which would generally be our advice, any employee with the menopause or going through the menopause and suffering serious symptoms, the advice is, for me, would be to consider that they may amount to a disability. Therefore, you should be looking at reasonable adjustments. So really good question. Again, quite technical, I think, in the overall advice, but we therefore have to then factor that as an employer to say, well, there's a good likelihood that these symptoms will be classed as a disability, so we'll act accordingly.
Yep.
Don't know. Again, any views, Nils, on that? I think
I just wondered, and I might have been wrong, whether there was a bit of a body of opinion that suggested it would be automatically deemed a disability in the same way that cancer is, but that seems to have lost steam.
I think that has lost steam. Because there has been seen to be some protection.
Yeah.
I think where you may see that argument come back is if you get a case where menopause symptoms are not deemed to be long-term or substantial. Yeah. All the cases recently have obviously been decided on the facts that they do. That's when I think you'll see some pushback if those fall short of that definition. Yeah. And then there'll be another argument that says either it's automatically a disability or it needs its own protected characteristics. So watch this space. As always, we'll continue to report on it. And that's it for this week. Another really interesting pod, Nils. Two important things for people to be aware of.
Yeah.
Goodbye from me.
And from me.